And thank you to everybody for coming out tonight. This is truly impressive to see such a large auditorium. And I thought what I'd do tonight in a fairly brief amount of time so that there are time for questions is just tell you a little bit about the story of Insite, the legal case. We know about Insite, the birth of the supervised injection site, and it was a long struggle, and it was a community struggle that brought things to the point where 3 levels of government actually agreed on something. And they agreed, in essence, that injecting drug use in this city should be dealt with as a health issue. Massive breakthrough. So after some difficulty getting to that point, the site opened. And it opened with an exemption from the Controlled Drugs and Substances Act. And that allowed injecting drug users to go into the site with their drugs and to inject under supervision. And they would not be subject to the criminal law while they were in the bounds of the site, insofar as their drug possession was concerned for the purpose of self-injection. And the staff at the site had protection from the trafficking provisions in the criminal code, inasmuch as they may need to handle drugs that are brought in by users. And the experiment, as we know from the science, worked very, very well from the point of healthcare and disease prevention and keeping people alive. And that's really what I think was so impressive about the site. And that's why it was so disappointing in the summer of 2006 that noises started to be made by the then, I guess, fairly recently elected Conservative government. They had been around for a while, but it was a Liberal government that had agreed to the exemption. And my clients came to me and they said, gee, we don't think this exemption is going to be extended. We think we're going to now be forced to take legal action. And so they were talking to me and they were talking to other lawyers, because I must say I am only one of a group of lawyers, phenomenal lawyers, who have participated in this case and made it possible. This has really been as much a community effort at the legal end of things as it was at the political and social activism end of things. So we started to talk in the summer of 2006. And we were making ready to file a court case. And unbeknownst to me, and I was probably pretty much along with this, I didn't realize that Vandu was also talking to John Conroy, and good for them. And so John Conroy filed a Vandu case just before PHS was about to file its case, and then all of a sudden, with minutes ticking down on the clock until the exemption was going to expire, the federal government said, we'll extend it. And so we breathed a sigh of relief and we said, okay, we'll see what happens next. So we made our way around to the summer of 2007, and we're in exactly the same position. And it looks like the exemption is going to expire. But this time the noises are louder and more persistent. So our clients, and I must say I have the most wonderful clients in the world, gave us instructions to file the case. So we did. And so the PHS Community Services Society, along with 2 individuals, Dean Wilson, whom you've heard from tonight, and Shelley Tomick, both of whom tremendously courageous individuals for putting their story on the line. It was their evidence about what their lives had been like, about how Insite had been in their lives. We filed our case with their evidence, and we ran around and we talked to the experts, and the folks at the Center for Excellence gave tremendous support. Experts from around the world also gave us support, much of it without expecting any fee whatsoever. They, it seems, had come to the conclusion that life was more important than anything else. And so again, there was this community coming together to file the case. And there was another extension granted to the exemption, but it only went to June 30th of 2008. And in early 2008, things were really looking like that was going to be it. There wasn't going to be another exemption. So off we went to trial. And we didn't know what was going to happen at trial. Mr. Justice Pitfield, who heard the trial, heard it on affidavit evidence. And the Government of Canada, to begin with, took the position that this shouldn't be just on paper. There should be witnesses heard. But the fact of the matter was, if we had gone to trial with witnesses, we wouldn't have gone to trial in 2008. It would have taken a lot longer. And then one day, I'm walking back from lunch after the trial is concluded with a friend of mine, and I run into Joe Arve on the street. And he said, "Have you heard?" And I said, "Have you heard what?" He said, "We won." I said, "What do you mean we won?" I didn't even know there was a decision. It had been suddenly released. And so that was great cause for celebration. And then the Government of Canada appealed, and there was kind of a collective groan. But we said, okay, well, if you're going to appeal, we're going to cross-appeal, because as Maxine explained, there have been two issues in this case. One is about the right to life and security of the person under Section 7 of the Canadian Charter of Rights and Freedoms. The basic argument is that the law has stood in the way of health care, and that's unconstitutional. And then the other part of the case is that, look, this is health care. And health care under the rules of Canadian federalism is a provincial responsibility. In Government of Canada, you are inserting yourself where it is not your domain. So we had lost on trial on the federalism, won on the charter. So when the Government of Canada decided to appeal the charter, we decided that we'd cross-appeal on federalism. And we went to the Court of Appeal. And in due course, the Court of Appeal decided in our favor on both issues. And so the government then appealed to the Supreme Court of Canada, which is how I found myself last Thursday on my first date with the Supremes. I don't know if it'll be the last, but I must say I could not have been prouder to be representing my clients in that case, and to have that as my first opportunity to be able to argue in front of the court. The court was extremely engaged, all members of the court. Question asking at the Supreme Court of Canada is not uncommon. It's the rule instead of the exception. Although I must admit that the volume and the nature of the questions and the interjections surprised me even a little bit. And by the time this case made its way up to the Supreme Court of Canada last week, that community involvement that had been there right from the beginning had mushroomed into an incredible collection of interveners. There were, I think, 10 intervening groups, most of them intervening in support of supervised injection and in support of Insite and the Dr. Peter Center. And as you heard from Maxine, a very large number of them were healthcare-based organizations whose essential point, I think, as we went from one set of arguments or one set of submissions to the next, was this is healthcare, this is necessary, and if the law stands in the way of it, then that is unconstitutional. The court did reserve its decision. There was no surprise there. The one surprise that happened was the next morning, when we then found out that we had either impressed or scared two of the judges so much that they were retiring. So that was a surprise. I think what it means for the case is that it is quite likely that the case is going to be decided, I'm going to venture to say, by the end of February 2012 at the latest. And the reasons for that relate to the rules around how judges can sign on to or write judgments after they retire. And the two judges that announced their retirements are scheduled to retire at the end of August. I think it is very likely that both of them will want to participate in this judgment. And I look forward to Insite being around. I look forward to other supervised consumption rooms opening. And I look forward, I hope, to our Canadian Supreme Court endorsing a law that is humane, endorsing a view of law that says evidence matters, and evidence really does matter, I think, in this particular case, and that endorses the view that the provinces in Canada have to be able to deal with healthcare issues in a way that is non-politicized. And so with some luck, we will hopefully get to that point. And in the meantime, this legal case is one small part in the bigger stream of drug policy. And looking down the road, the most important thing is not going to be this legal battle, or if there's another legal battle, that legal battle. The most important thing is community engagement and political engagement, because that's the way to prevent cases like this from getting to the court in the first place. So I guess the message I have to leave with you tonight is stay involved, get out there, and shape healthcare policy in a socially just manner. Thank you.